Good afternoon, everyone. We're here for another edition of USPTO Hour. Today, your hosts are me. I'm Amy Cotton. I'm with the Trademarks Organization. I'm the Deputy Commissioner for Trademark Examination Policy. And with me today is my friend Mantia Pressy. She's the Director for the Trademarks Register Protection Office. Since about 2020, Mantia and I have basically built the Register Protection Office from scratch to deal with the growing number of suspicious applications and filings that we have seen. And so today we want to give you some updates on where we are in our fight against fraud. The questions during the presentation, please send them to usptohour@uspto.gov. We're no longer using the chat for questions, but if you do have technical concerns, the technical folks are monitoring the chat and can help you. But if you have substantive questions about the presentation, please send them to usptohour@uspto.gov. Before you ask, the slides in the presentation will be available. It's being recorded, and it will be available on the USPTO Hour webpage in a couple weeks. It takes a while to put the video together, but it'll be available for your viewing in a couple weeks. So go to that USPTO Hour webpage, and you'll find this one as well as all of the past USPTO Hours and their recordings. So we encourage you to do that if you feel like you missed anything here. And we will try to answer your questions in the chat as we go, but obviously we're busy presenting, so that'll be a little challenging, but we'll continue to try to answer those questions even after this presentation is over. We're really going to focus on the questions, though, that are relevant to this topic of fraud today as best we can. So I'm going to turn it over now to Mantia to start us off and give you a little bit of background about the scam problem that we're seeing here. Mantia, over to you.
Thanks so much, Amy. Hi, everyone. Good afternoon. Happy to be here. I have the privilege, as Amy said, of leading the Trademark Register Protection Office. Our office has one core mission, and that is protecting the integrity of the U.S. Trademark Register. Right now, a critical part of that mission and our most urgent priority is combating the explosion in trademark scams. These schemes target brand owners at every stage, sometimes before an application is even filed. Now, it's important to understand the USPTO's role. We do not have direct criminal or civil enforcement authority, so we can't prosecute bad actors or stop private companies from sending you a misleading notice. But that does not mean that we are powerless. We fight back by empowering you with the information needed to identify these scams and protect yourselves, taking decisive administrative action against fraudulent activity that occurs before our agency and pursuing domain name takedowns, and supporting federal agencies that do have enforcement power by providing them with the evidence they need to act. Today, I'll focus on the first point, empowerment. I will share tips and strategies to help you protect your brand, and then I'll turn it over to Amy, who will detail the specific actions the USPTO is taking to hold bad actors accountable. We are witnessing a dramatic and concerning increase in trademark scams targeting our stakeholders and USPTO systems. To put that in perspective, reports to the USPTO's TM scams at uspto.gov mailbox have surged over 1,000% in just 2 years. The primary threat we're seeing is direct impersonation of the USPTO, where criminals pretend to be us. These scams typically start with a tempting but deceptive offer for low-cost services, for designing a logo for your business, a tactic that's calculated to lure in unsuspecting business owners. This isn't an isolated issue. It reflects a major national and international problem. The FTC confirms that impersonation is a top 3 fraud category, causing financial loss to a significant number of victims, both in public and private sectors. So here, looking at the current fiscal year in particular, you'll see in just under 8 months, we have reached 13,178 scam reports to our mailbox. We have nearly equaled last year's record-breaking total, which was 13,548 reports in only a fraction of the time. So the scams are escalating, they're evolving, and as I mentioned, you'll hear what we're doing to combat the scams that we're seeing before our office. As I mentioned, many trademark scams begin before a business owner even files an application at the USPTO. Some of the largest trademark scams are perpetrated by entities advertising low-cost trademark filing services online or soliciting potential trademark applicants using questionable tactics. We often refer to these entities as filing firms. Although not all filing firms are run by scammers, it is often difficult to determine whether the various fees and services are reasonable, necessary, or in the case of legal services, offered by actual attorneys. In the next slide, I'll describe how filing firm scams typically work and how using them potentially impacts any trademark application they file on your behalf. It almost always starts with the bait. These firms target new entrepreneurs on social media or through ads with offers that seem too good to be true, like a professional logo for just $50. Once they've secured you as a customer for the design, they make their real move. They'll create a sense of urgency and say, now you have this great logo, you need to protect it immediately, and offer to help you file a trademark application. But USPTO rules are crystal clear. Anyone representing someone else in a trademark matter must be a licensed U.S. attorney in good standing. These companies typically are not law firms, and their employees are often not qualified or authorized to give legal advice or file applications on your behalf. From the very beginning, their representation is often illegitimate. Scammers thrive in confusion, and that's exactly what this environment creates. They make it difficult to know if fees are legitimate, if services are needed, or if you're getting advice from a real lawyer. To get around the attorney requirement, scammers often resort to outright fraud. They might invent a fake attorney name and bar license number, hoping no one will check. In more malicious cases, they will find a real attorney's information online and use it on the application without the attorney's knowledge or consent. This is identity theft, and it invalidates the application while putting a real attorney's reputation at risk. Unnecessary and inflated fees are the financial trap. They'll quote a very low initial price, perhaps just the basic government filing fee, to get you in the door. But shortly after you pay, the demands for more money begin. You'll get invoices for fabricated costs like docketing fees, registration processing surcharges, or mandatory publication fees, none of which are real. They are also frequently will overcharge for the actual government filing fee, and in cases where they actually do file an application, pocket the difference. Because in most cases, an actual attorney did not prepare or file the application, and again, since only attorneys can represent others before our agency under our rules, the application is often fatally flawed and can't be corrected. Your only recourse is to file a new application in this instance, losing all money paid in filing fees and for any trademark services paid to the filing firm. These images are from 4 websites operated by a related network of filing firms. They all claim to have expert attorneys on staff. However, their claims fall apart under basic scrutiny. Notice the name Dennis Morgan. He appears as an expert on all 4 sites. On one site, that single name is tied to 3 different photos, including 2 men and 1 woman. We see that same deceptive pattern with the names Emma, Alita, and Orlando. This is obviously not a mistake. This is a clear indicator of a fraudulent operation. So how can you protect yourself from these scams? The good news is there are 2 simple but powerful steps you can take. We call it ask, then verify. First, ask for credentials. Don't be shy about it. For the company itself, ask for its full legal name and the state where it's incorporated. For the person you're dealing with, if they claim to be an attorney, you need 3 basic pieces of information: their full name, the state where they're licensed, and their bar number. If they hesitate to give you this, that's the first major red flag. But getting the information is only half the battle. The critical second step is to verify it independently. Don't just trust what they tell you. Go to a neutral source like the American Bar Association website, or even better, the official state bar directory for the state they've claimed. look them up, and call or email them directly using information from these sources. This two-step process takes just a few minutes, but it's the single most effective way to separate a legitimate professional from a scam artist. Later in the presentation, we will be sharing links to all the resources we cover today, including the ABA website and the state bar directories, which are essential tools for avoiding scams. So you've successfully filed your application, either on your own or with an actual U.S. attorney. You might think you're in the clear, but that's exactly when the next wave of scams begin. The scams don't stop, they just change their tactics. It's crucial to understand how these post-filing scams operate. They are made possible by a fundamental aspect of trademark practice and procedure before the USPTO, transparency. By law, all trademark application records, from the application itself to the registration, must be publicly viewable. It's a core principle, again, of transparency. But there is an unfortunate downside to this. The moment you file, your name, your address, and your email become part of the public record. And this public database is a goldmine for fraudsters. They actively mine this data to find their next targets. Soon after you file, you should expect to be contacted by a scammer. They'll send you things that look incredibly official, fake invoices, urgent sounding warnings about your application, or misleading offers for services. And here's the most deceptive part. Many of these scams are designed to look like they came directly from the USPTO. They use our logo and official sounding language to trick you into paying for services that are either completely unnecessary or don't even exist. Okay, so how do you spot one of these scams in the wild? You just need to know the red flags. Think of this as your scam detection checklist. First, and this is the biggest one, pressure. Scammers will create a sense of panic, telling you that you have to pay immediately because of some imminent deadline. But the USPTO will give you ample time to respond to any real deadline. We don't operate on surprise 24-hour notices. Second, check the money. Scammers will request fees for odd amounts or for services that don't exist. Your best defense is our official USPTO fee schedule, which is on our website. If a bill doesn't match a fee on that schedule, it's a major red flag. Third, check the sender's email address. This is a simple but powerful check. If it's officially from us, the email will always end in @uspto.gov. No exceptions, not at usptoservices.com or at trademark.office.org. If it's not from a .gov address, it's not from us. Finally, listen for specific buzzwords. Scammers love to use official sounding but meaningless terms. If you see requests for fees related to attestation or verification processes, be very suspicious. These are not official USPTO procedures. If you believe you've been targeted by a scam, there is a clear protocol to follow. First and foremost, do not engage. Do not make any payments or provide personal information. Second, verify independently. Use the USPTO's official TSDR system to check the actual status of your application or registration. This is the official source of information about federal trademarks. Third, consult your counsel. If you're represented by an attorney, contact them immediately for guidance. Fourth, educate yourself. We maintain a comprehensive list of known fraudulent solicitations on our website for your reference. Finally, report the incident. Reporting these attempts is critical to our educational efforts and helps protect other applicants and registrants. So here is on the reported slide, you'll see the first link is to the ABA website, and that's the tool that I mentioned earlier, where you could go and verify that the individual you're working with is in fact a real US licensed attorney. And under reporting scams, we encourage you to report them to us at our TM Scams mailbox, then report to the FTC and the FBI. They have the enforcement power that we don't. So here's a real-world example of an email impersonating the USPTO. Unfortunately, we receive reports about fraudulent domains like this every single day. In fact, this email is a perfect illustration of the red flags that we highlighted in a recent scam alert about a T's formative domain name. Notice the telltale signs. First, the domain name. It uses a hyphen and extra words, trademark-gov, to appear legitimate. Second, the domain extension. It ends in live, not the official .gov extension that all federal agencies use. These are classic indicators of an impersonation scam. Looking ahead, we're exploring long-term technological solutions. We have initiated a request for information, or RFI, to identify tools that could verify whether a communication is truly from the USPTO. This process is still in the very early stages, but our goal is to find new ways to help you authenticate our communications. Along with the tips we shared as part of the pre-filing shields, there are some specific actions that you can take to protect yourself from post-filing trademark scams. We recommend implementing a two-part defensive strategy. Part one is managing your public information. For your email, it is best practice to use a dedicated address solely for trademark correspondence to minimize exposure. For your address, use a PO box as your public mailing address. You must provide a domicile address, which is a place where an individual applicant resides and intends to be their principal home, or for an applicant that's a juristic entity, the principal place of business or headquarters, but you can ensure that your domicile address remains private. To do this for individuals, you would enter your home address in the domicile address field of the electronic form and a different address in the mailing address field. And also did just want to flag here, and I know Amy will mention it as well, you are actually not required to provide your telephone number when you file. It's helpful for us to contact you if there are quick questions that we can try to resolve by phone, but certainly it's not required. And again, scammers will use that information to reach out to you. So part two of the shield is adopting a verification mindset. Always pause and verify any request you receive. Scammers create false urgency. Any communication demanding immediate payment should be considered a significant flag and treated as a potential scam. The verify component of your defense shield consists of two primary actions. Action one, consult the official record. The first step in any verification process is to check your applications or registration status in the USPTO's TSDR system. This database contains all official correspondence and documents. If a notice or demand you've received is not reflected in TSDR, it should be considered illegitimate. Action two, engage your legal counsel. If you are represented by an attorney, it's imperative that you contact them prior to paying any fee or responding to any solicitation. And with that, that's it for me. I'm going to turn it over now to Amy, who's going to tell you about some of the things the USPTO is doing to fight back against fraudulent and improper activity before our agency.
Thank you, Montia. Let's advance to the next slides. What are we doing? Next slide, please. Well, we have a lot of resources. I noticed some people in the chat are saying, put up this notice, put up this notice. We've put up all the notices. Whether or not folks read them, that's a different issue. But we have a library of customer resources where you can learn the risks of non-attorney filing firms, what data is public in trademark records, what are the common signs of scams, what to do if you're scams. We have misleading solicitation and fraudulent scams just listed. You know, if you want to see if somebody who's contacted you is a bad guy, we have a page for that. We have a checklist. We tell you to use TSDR to check to see, as a source of truth for your application. Did we send you something? Go to TSDR. It's in there. We have, links to our fee amounts, so you can't get overcharged, all that kind of stuff, but we still hear in our surveys that we do of our customers, they wish there were more and bigger warnings in the application forms. They didn't know that their data would be immediately made public, even though it says it on all of the forms and all the web pages that we have. And as Montia said, we are required to make all of this information in the applications form publicly viewable. We warn them that it's going to happen, but it still happens. What more can we do? We're always looking for suggestions, so post them in the chat. You already have that as well. but one of the things that we think was a suggestion in one of our surveys was to put a video right embedded in the trademark, the trademark center in the application form. Maybe folks who don't like to read will actually watch the video. Maybe we can put something flashy on it, but we'll see what we can do to make those warnings bigger. But it's a constant battle. Next slide, please. So what action are we taking? One of the things that we're doing is domain name enforcement. USPTO impersonation is just rampant. Government impersonation is rampant. Customers receive emails, phone calls, texts purporting to be from the USPTO. And then when these folks reach out to us in the tmscams@uspto.gov box, we will record the domain name if there was one from which they were contacted. We'll look to see if we can take any enforcement action. We rely on our USPTO registrations. We registered our own marks if there's an infringement situation. But if it's just impersonation and not infringement, then we will go to the registrar, the domain name registrar, and ask them under their government or impersonation misleading provisions of their terms of use. We'll ask them to take down those domain names. Some do it. It's a lot like counterfeiting. Some do it. Some don't. So all we can do is keep trying. And a lot of times these scammers will just pop up with another registrar with the same domain name, or they'll pop up with a variant of it. So you know that it's just sort of that game of whack-a-mole that keeps happening. And it's not feasible for the USPTO to use your user fees and buy up all of the ones that we took down. If we bought them all using your user fees, it would be a huge line item for us. So we just continue whacking away at these as we hear about them and as our resources allow. We have started a market research effort to try to find an AI tool that might help us identify when a communication is impersonating the USPTO so that we could provide access to that tool for our customers. Meaning if a customer got a solicitation, got some sort of communication, and they wanted to see if it really was us, we'd have something on our website where you could actually, scan it in and send it through the AI tool, the magic AI tool that we don't know if it exists yet, and it would tell you whether or not it really was from us or not. I mean, the easiest way to deal, TSDR, just go to TSDR and see if it's in the file. If it's in the file, we send it to you. If it's not in the file, then we didn't. Maybe an AI tool is not helpful there, but we're trying everything. Our longer term solution is to create a trademark portal. It's kind of like your banking app on your phone, and it will offer secure communication between us and the customers. That would mean we would no longer send out any communications other than alerts that something new is in your portal. But that's a year or two away. We have a lot of steps that we have to take before we get there, and it really would, though, increase the security of our system and curb those solicitation schemes. So we're working hard to try to get to the place where we can do the portal. Next slide, please, Montia. Okay, how else? If the fraud's already on the register, what are you doing? There's all these scam applications that are sitting on the register and they're a problem. We know they're there. We're working to find them. We're working to remove them from our systems. We encourage you all to use any third-party tools we've created for you to help you to take those things off, like letters of protest, expungement and reexamination, non-use proceedings, opposition and cancellation. Now, on our part, though, we're using these mechanisms that you see on the screen to remove those invalid filings. Now, the most effective bang for the buck, in my opinion, is the administrative sanctions program. That's that first one, that sanctions orders. It takes a lot of work to identify the scam, pull together the evidence, draft the sanctions orders, and actually process the applications and registrations in the system so that we can remove thousands of invalid filings through one set of orders. We have issued 11 orders just this year, and that will remove about 10,388 invalid applications and registrations from the register. So these will no longer be blocking 2D likelihood of confusion sites for good faith applications that come behind and conflict. Now that next box, misassignments, we also misassign applications at the filing phase, basically, when we have evidence that an attorney's credentials have been hijacked and used to file those applications. We removed 8,041 applications this year alone, this fiscal year alone, where we denied a filing date. What we do is if we find out an attorney contacts us and says, my credentials have been hijacked, or we know of that, we'll try to contact that attorney, get a declaration from them saying that they didn't file this, these applications, once we have that declaration, that's evidence that we can use to then misassign them and get them from out of the system and not even go into an examination. Next, on the next box, we use our authority under the Trademark Modernization Act to initiate non-use proceedings against registrations that appear to be not in use, particularly those specimen farm registrations. So these are registrations that are controlled by a set of filing firms that use a specimen farm website. Now, a specimen farm website, it looks like an e-commerce platform, but it really has only been created for the purpose of looking like it's an operable website that corresponds to the specimen screenshots that we see in applications. So it was created for the purpose of getting a registration from us. It was not created to actually sell the goods. So these marks on these websites are not really in use. You can't actually buy the tour bus that's right next to the pink shorts listed on that website. That doesn't work. But we use this evidence to, to re-examine these registrations and ultimately to remove them from the register. And you can see what we've removed so far. That fourth box, the audit box, this is our post-registration audit program. We've had this for years, actually dating way back to 2012. We can initiate both random audits now and directed audits, targeted audits of the post-registration maintenance filing. So then we start looking to see if those marks are actually in use and whittle them down or cancel the registrations entirely. Lastly, we've also started issuing office actions on cases that we've been holding for administrative review, but we have not yet issued a sanctions order on it yet. When we think it's appropriate, in a case where we know that the U.S. counsel is not supposed to be there, it's not a real counsel or whatever, we'll remove that counsel from that's listed, appears to be the scammers. Then we'll issue an office action asking for new counsel in order for the application to proceed. If they abandon, which most do, then that one is gone and anyone who's been blocked behind it can then move forward. Next slide, please. All right, let's talk a little bit about that first box on the last slide, the sanctions program. As I said, it's been the most effective at removing scam applications from the register. Here's how it works. So I told you that Trademarks Register Protection Office was established in 2020. It's to assist with the enforcement of USPTO rules of practice, including those on signatures, certifications, and representation before the office, as well as the website terms of use and the USPTO trademark verified USPTO.gov account agreement. The RPO works collaboratively with our policy office, the Office of Enrollment and Discipline, and the Solicitor's Office to address rule violations. So when we have a rule, we have to enforce the rule, and these are the people who are doing that. We're looking at the nature of the rule violations, particularly focusing on widespread patterns of behavior that indicate an intent to circumvent those rules. We call this fraud in presentations, but individually, it doesn't really look like fraud in one application. We're looking at a widespread pattern because that raises an inference that the scammer had an intent to commit fraud, an intent to circumvent the rules. As such, the typical sanctions when we see that widespread pattern is invalidation of the application and registrations involved in that scam. And here I want to be clear because I know there was a couple of questions about this in the chat. Well, in the USPTO hour, that's where you're supposed to send your questions, remember. It does not matter whether the applicant or registrant knew that their attorney or their fake attorney was circumventing the rules. It does not matter. The agent's actions are imputed to the client. The USPTO cannot rely on the application that was filed with false information. We cannot rely on that. We're not going to examine it. You cannot rehabilitate an invalid application. Just refile it without the scammer involved. And you can file it on your own using our resources. We have a great set of tools that are available for pro se applicants, or get a reputable attorney, not a scam attorney. And I know they're hard to find, but the American Bar Association can help with that. But use a reputable attorney who's well-versed in trademark law who will be able to help you. We have attorneys who say, well, I want to help the scammed victim, the victim who was scammed, and I want to rehabilitate the applications. Again, you cannot rehabilitate them. Just refile, start over, because those applications are more than likely part of it. If they're being held for administrative review, more than likely they're going to be part of a sanctions order, and more than likely they're going to be terminated. Now, in cases of rule violations that aren't technically part of a pattern, that indicates an intent to circumvent the rule, we can still issue a sanctions order and we can still strike that particular filing. So simply because you're violating a rule in only a couple cases or one case, you think, well, it's not a widespread pattern, so I'm okay, I'm not going to get sanctioned. Well, you might, because these are rule violations. There are rules for a reason, and we're enforcing those rules. Also, know that the Register Protection Office can deactivate a USPTO.gov account for violations of the account agreement, as well as violations of the rules. So we're going to get to that shortly. Let me go to the next slide, though. And I just saw somebody in chat saying reputable attorneys are hard to find. They can be hard to find for a pro se applicant who is not well versed in how to find a reputable attorney, and they're easily lured by online filing, these scam filing firms online who say that they'll charge you $35 to get a registration from the USPTO. So yes, it is difficult to find a good attorney who's going to help you if you don't know the playing field. If you are an attorney in the field, you know where to find the reputable. I know where to find the reputable attorneys, but a lot of folks out there don't. And they then fall victim to these scam operations. And it's really, really sad. And we hear those stories to the tune of 100 emails a day, I want to say. Maybe it's more than that, from scam victims constantly who are being scammed. And it's heartbreaking. Okay, signature rule. In nearly every presentation I do on fraud, I reiterate the signature rule. Here it is. You cannot delegate your signature. You cannot delegate your signature to your support staff. You cannot even delegate your signature to your support staff on a CAR form, on a change of address form that doesn't include a verified statement. Signatures are not technical, they are substantive. If you do delegate your signature, you are potentially subjecting your client's application or registration to invalidation through a sanctions order. The submission is improperly executed if the signature is bad, whether that be an unauthorized or forged signature or a false signature, which was authorized, but it's not the named signatory. Now, some of you might say, well, 35 U.S.C. Section 26 says you can perfect defective signatures. However, a defective signature is when the wrong party accidentally signs. It is not defective when you knowingly or with reckless disregard violate the rule and delegate your signature. And we have warnings all over our forms that you cannot delegate your signature, but in most cases, you cannot correct an improperly executed signature. But if you have an improperly executed signature on a file, and then we find out that there's other rule violations or account agreement violations in your portfolio, we're going to take a much closer look at your activity. We take signatures very seriously, and you should too. Next slide, please. In order to access and file electronic forms and submit trademark documents to the USPTO, trademark applicants or their attorneys must register for and use a USPTO.gov account. Use of a USPTO.gov account and any other USPTO website or system requires users to agree to and comply with the terms of use for the USPTO websites. Users who wish to file these documents through TEAS or Trademark Center must have their identities verified and are further bound by the verified account agreement. Account holders must select a user role to associate with their account. The following user roles are available: owner, U.S. licensed attorney, Canadian attorney or agent, and attorney support staff. The USPTO regularly monitors USPTO.gov account activity in the trademark electronic filing system for compliance with the agreements. We have deactivated 1,129 accounts for violations of the account agreement over the last 3 years, and that number will go up because we're ramping up account monitoring, as we'll talk about in a minute. The account agreement says clearly that accounts are individual and cannot be shared. Your user role dictates what you can do from your account. And let me be clear, there is no trademark consultant user role. You are either an owner, an attorney, or the attorney's staff that is directly supervised. Non-practitioners cannot file submissions on behalf of applicants or registrants. That constitutes the unauthorized practice of law, unless they are attorney-sponsored support staff. We can monitor your submissions so we know that an owner account should not be filing submissions on hundreds of different applications unless that owner actually owns all of those applications. But I am done lecturing you about rule violations. I would rather talk about something more exciting, so I'm going to move on to the next slide. Mantia. Developing anti-fraud IT tools. We have used our people. Our greatest resource is our people, but we've used our people and our manual processes to fight fraud for the last several years. But we are now on the cusp of automating processes our staff has developed to identify, quarantine, and dispose of invalid filings and get them out of the way of our good faith filers. Next slide. So this is what I was talking about. We're really excited about this new account monitoring tool. We're using it in beta form. It identifies filing behavior anomalies in accounts. Again, as noticed previously, if the filing behavior does not match the user role, our tool flags that account and our team will review it and take appropriate action. The tool uses unsupervised machine learning to analyze over 40 different attributes within submission data, helps detect unusual patterns that may signal fraudulent activity. I can't share the details because I don't want the scammers to know precisely the data we're looking at. So everything's kind of like blurry here, so you can't really see it. But it definitely, human is in the loop. This just flags activity and we have humans looking at it. Next slide. Now this month, we're deploying a customized case management system to organize and automate our internal administrative review data. This customer resource management system has been customized for us to organize and track our reviews of suspicious filings, allowing us to aggregate tips from our TM Scams mailbox to process account shutdowns and see scam activity more clearly. It will give us the ability to better track administrative review matters, create connections among matters, assign and route tasks, and integrate with the trademark database, all of which will result in time savings and efficiencies in conducting reviews, taking action against rule violations, and onboarding new employees because everything is in one place. So it's very difficult to train new folks coming in on our processes because we have multiple spreadsheets housed on a couple of attorneys' different desktops who are trying to, manage version control. So it can be very cumbersome to get anybody new working on these matters because they're using these spreadsheets that you can't lose control of. But this tool will solve for that. So we're really excited to see this deploy. I think it's actually tomorrow. So that's pretty exciting for us. Next slide, please. We're then going to link up that case management system to bulk transaction workflows that will allow our attorneys to move groups of applications suspected of rule violations out of examination and into a workflow for administrative review. These bulk transaction workflows allow us to issue administrative notices through the system that cover tens of thousands of applications and registrations rather than issuing them one by one, or having an IT team have to take these manual actions. The Register Protection Review tool allows our attorneys to do a batch transaction to upload, for example, a public note into 1,000 applications and registration electronic records in a matter of minutes. Maybe that public note is that we're removing and withdrawing the attorney of record information in hundreds of thousands of records because the attorney information was faked or it was hijacked. But we can do it in a bulk transaction because our normal systems for examination are one by one by one. So this is actually working in bulk. Again, everything is predicated on a human in the loop, looking at these things and making sure that we have done everything we need to do to prove the case that these are scam applications. Next slide. So here's another batch process user interface we now use to misassign application serial numbers in attorney credential hijacking cases. So just last week, no joke, we misassigned 610 application serial numbers all at once through this tool. You can see in the upper right-hand corner that the TSDR record now shows the application is dead through that status indicator icon with the lines through it, the red icon. It's a huge improvement for our team, making this task that used to take 2 days just take 30 minutes. So again, this stuff gets bad applications off of the register and out of your way. And the more quickly we can do it and efficiently we can do it, the more stuff we can get that doesn't block you. And the more we can focus on preventing bad things from entering the system altogether rather than trying to clean up once it's already here. Next slide, please. Now, lastly, another tool we're exploring in that market research that I talked about is a fraud risk predictor. We do not know if this exists yet that we could use, but we're asking the industry, market research, hey, tell us, does anything like this exist? And could you tailor it to our systems? So we issued a request for information to identify commercially available AI tools that would review account data, filing data, credit card data, to detect indicators of fraud and calculate the risk that the submission is part of a scam. Now, the submissions that indicate a high likelihood of violations of the rules of practice, the account agreement, the website terms of use, they could then be automatically diverted to the Register Protection Office for administrative review. We do this manually now. You can see this is the tool we have. We go through this tool and manually can pick out and put serial numbers into a spreadsheet. So we can look at account filing data and then pull serial numbers out and put them in a spreadsheet. Once we have that spreadsheet, then we can pull things out. But it's a long, involved process, and it's a manual process. We'll actually take tips from the TM Scams mailbox and then start looking at these things as well. So then to have that initial screening done that identifies possible scams and implicated applications and registrations automated, to have that automated, it would allow our attorneys to review and validate the tool's findings and then quickly start drafting a sanctions order, allow us to move that stuff off the register and out of your way. This is just in the concept phase, but it's truly exciting to think about how this could amplify our work on scams and take, allow us to have more people focused on this effort and get the stuff out of your way, and then focus a lot more on, as I said, preventing things at the front end. So there's just a lot going on in the register protection space, as you can tell. We're excited to see how this transformation from AI and automation will transform us and our work. Automation and AI, let's be real, it could also accelerate the scammers' efforts, but we will be ready. We're looking forward to the continued fight. That is actually all we had prepared for you today, but we certainly have plenty of time for questions. So we are going to now, you don't have to share your screen anymore, Mantia, and we can now go and look to see what we have in the box. Somebody asked an address where they can report scams to the USPTO. It is tmscams@uspto.gov. So please let us know. We have, folks manning that box who can give you guys information about whatever you're seeing. We take tips from that and see if we can put them in our new case management system and see if they link up to other reports that we've gotten. Let's see. There was a question, and I did answer it in the box already. What can licensed attorney do to assist applicants who have been scammed? Is there any way to recover applications which are under review by the scams department? Refile. I did address that again, but I'm going to hit it again. Refile. If we are holding it for administrative review, there is a very high likelihood that it is part of a scam. There is a very high likelihood that we will issue a sanctions order that will ultimately terminate that application or that group of applications or registrations. And so if you want to sit there and wait for us to get that and terminate it that way while your client's sitting there, you can do that. I don't think that's the best idea. I think you should just refile and start over without the scam. All right. Question was, how does the USPTO monitor trademark fraud or infringement? Well, I think we've talked about that quite a bit through all these tools. We're looking for widespread patterns of behavior that indicate an intent to circumvent our rules. Mantia, do you see anything in here?
Reading through. Getting caught up.
Why not ask outside attorney firms to buy up the domains and hold them in trust for the USPTO? We could each buy a handful. Sure. We're going to post a web page with all of the domains URLs that we have seen, investigated, and found to be a problem. All of them that are in our sanctions order. So we will be putting up that web page, and if you all want to purchase those and hold them so a scammer can't get them, we'd appreciate that. I hope a scammer is not listening and decides to do the same thing. But yeah, we would love that. But we're not in a position to do that with the almost 1,000 domain names that we've gotten. Is there any action being taken to stop the absurd number of scams related to abandoned trademark applications and people receiving messages claim that a third party is applying for this abandoned trademark? How would you like us, what action would you like us to take? That's the question. And if you'd like to put that in the chat, that would be helpful. We put out alerts. We put out videos. We post warnings on the website, warnings everywhere that we can think of to try to address this and educate our customers. Now, problem is a lot of our customers are not in our subscriber base. So they're not getting the USPTO alerts. So we post on social media. Well, they might not be getting our social media posts. So we partnered with the Federal Trade Commission. We co-authored a blog to push out to their subscriber base. We partnered with the Better Business Bureau to push out an alert on these sorts of things to their subscriber base. So we're trying to reach beyond our, the customers who are here today, who are hearing what we're having to say, to those who are not here today, who are the ones who are most likely to get scammed. But these are text messages that are going out from a scammer to random people, maybe somebody who just filed. We put warnings up, and that's kind of all we can do here. Again, we don't have civil enforcement authority, and even if we did, a lot of these folks are probably not in this country, and it would be difficult to try to get scammers who are based in other countries. Okay.
Our best tools here are really raising awareness. Again, it's we're trying to expand our networks to include folks that, again, have never used our services or are reaching out and being contacted by those filing mills or who are designing those logos. To me, that's where we make a big impact. If we can get to the folks that are thinking about a logo for their business and they're the most susceptible to the filing firms that are going to exploit them and try to design that logo and then file a fraudulent, improper application on their behalf.
Somebody asked if we have statistics on the new targeted post-reg audits versus the random ones. Montia, we really have not done many of the targeted audits yet, so there's no
Correct.
statistically significant data to present on that.
IT is the issue. We are looking to build a new tool, one of the tools that will give us the ability to search and identify. And again, we're primarily looking at specimen farm connections. So if there's a specimen farm connection that's identified, let's say, as part of that maintenance submission, that's something we'd like to issue a directed audit on. But we're looking to have some fields built into one of our existing tools that would allow us to search and identify based on that information. So for now, just we're falling or coming across them just sort of randomly, but we want to be able to do like we're doing in their expungement re-exam space, where we're able to kind of move forward and do it on a larger scale. But it's harder because it's maintenance submission based instead of just a registration that registered within a set time period. So it's a little harder to identify and move forward with a directed audit for that reason.
Somebody asked, does the new USPTO system stop a non-attorney with a USPTO account from filing applications in the name of others? No, this is just a monitoring tool that flags an account that's doing things that don't match the user role. So theoretically, if there were, say, an owner account, so this is a USPTO.gov account with an owner user role, if that account is being used to file submissions on multiple serial numbers, that account would get flagged, and we would have a human look at it to see what's going on with that account. If it's an owner role and all of the submissions are being filed on different serial numbers and each one has a different name of a different owner, then we know that person is not acting, they're not following the terms of the account agreement, where the owner is only filing on the owner's own stuff. So for that reason, then we could terminate the account. We could deactivate the account. The account holder would get an email from us saying we're deactivating the account, and that person can write back and argue the case, and we will adjudicate that and figure out what's going on. Maybe that person has the wrong user role. Maybe they're an attorney, a licensed attorney who should have an attorney owner role. I'm sorry, an attorney user role, and then they would have to ID verify a new account with the new owner role and put in their VAR credentials into that account. So there are things we can do if they're in the wrong account or the wrong user role. We can manage that, but it wouldn't automatically shut down the account and deactivate it without a human looking at it to make sure that the submissions are not following the account agreement. And we might look deeper at it to see if there are rule violations going on, the rules of practice, signatures, certification, representation, that sort of thing. But we're not certainly not taking the human out of the loop here. It just flags it for us. And we only have so many people who can look at the results of the flag. We just hired 3 more. They're attorneys who are coming on board. Yay! In June, we're very excited about that. So we'll have more people to analyze the findings and figure out what action to take based on what they see. But again, that's why I wanted to really hammer, okay, we're looking at the rules of practice, we're looking at the account agreement user roles, we're looking at all of this different data to see if you are following the rules. And if you're not following the rules, then we need to take action, because that is our job, to enforce the rules. And for decades, the enforcement of the rules was hit or miss because of, we just presumed good faith. We presumed that everybody was coming in here and wanted a trademark and was going to do the right thing. Well, that's not the world we live in anymore. So we had to change our posture starting about 6 or 7 years ago and change tactics and really focus on rule enforcement. So yes, that does create barriers to entry, deliberately so, but for the scammers, but also for good faith applicants. And that is a shame, but that's where we live in. If we want to make sure that the register is accurate and useful for businesses to make quick decisions, what is available, what's not available, they want to look at the register and make that decision. That's what it's for. If it's not useful for that purpose, because it's not accurate, because there's just lies all over it, then people aren't going to rely on it anymore, and people aren't going to get trademark registrations anymore. And we're out of work. We're out of business at the trademark office, which, okay, but that means litigation costs go sky high to prove ownership of trademarks. And we're here to keep ownership costs down. So we take our job very seriously, because we know that we provide a valuable service to you all, but we also know that fighting fraud means that it affects everybody and creates friction for everybody to get in the system. So we're trying to minimize the friction for our good faith applicants while maximizing the friction for our bad faith folks, and trying to figure out the best ways to do that, which is why it's taken us 6, 7 years to find the right policies that we're now automating. We found the right balance for all of due process and all of that, and now we're automating those now so we can move even faster. All right. Somebody took me up on my abandonment scams, how to implement. Perhaps add a statement to the official notice of abandonment describing and warning people about these types of scams. That's not a bad idea. Thank you, Allison. I appreciate that. You always have good ideas. I appreciate that. We can think about that and push them to the petition to revive process. Yep, got it. Check. I like that. Okay. In-house counsel sometimes identify themselves as an officer of the applicant and do not appoint themselves as attorney, but sometimes identify themselves as an attorney for the applicant. What role should those people select for their account if they want to be able to act in both roles? Well, that's a hard question. I'm going to have to think about that, Allison. The in-house counsel identifies, because they're either an officer, yeah, they're okay. I think they would be the attorney role. I will consult and get back to you. I think the attorney role is better than the owner role in that situation, because the attorney role allows you to then touch more of your client's files, your corporate files, corporate applications. So I think the attorney role is better in that instance, but I will research that with my folks and the Brain Trust and get back to you. Unless you have an idea, Montia. Yeah.
My thought was yours, the attorney, but let's check with our our experts on that.
And this is why it's good for you all to use the USPTO Hour at uspto.gov, because then I can follow up and get back with you. I have your email and I can write back to you. So that's why we push you to this special, this box rather than using the chat. Okay, this is, Okay, I think this is IT, not Amy or the host. But anyhow, if could, I notice when a trademark application is filed, the attorney's bar number appears to be partially hidden in asterisks, for instance, in the official filing receipt. To the public, does this mean that the attorney's bar number is not visible? And couldn't this practice be applied to part of the applicant's name, address, and their email address? So you're talking about data masking. We started masking the attorney bar information and the represented applicant's email address about 4 years ago. And we did that in response to, people telling us that they wanted to do this. What happens though is that it doesn't always stay masked. So if we, as you know, we have a lot of data products. We have a lot of open data portals with various bulk projects. We just have a lot of different data products. And what happens is that if something gets published in another product, it becomes unmasked. Then we have a privacy incident. We have to go and report within 24 hours to the security office. We have to go through a lot of process every time a field gets masked because it is considered to be PII. Now, we've been clear in all of our communications that all of the data that we collect is public. We tried to mask a few fields because it was getting scraped by scammers, but that doesn't transform it into private information. It's not private because all of our data is public because we are a property register. We are a government property register. We're identifying claims to property that people may have disputes with. And if they have disputes, they need to be able to reach whoever's claiming and adjudicate that. They need to be able to, cease and desist. They need to go into settlement. They need to litigate. So they need the data that we are making available. And by statute and rules, we're supposed to make that available. When we try to mask data elements as a courtesy to prevent scammers, it becomes unmasked in different products. Now that's on us. We're not very good at data masking right now, and we've got to get a handle on that. But we need to find a different way to address this problem, and we haven't quite figured out what that is. So people expect that their data that they give us is private, but we've said clearly everywhere that it is not private, it is public, and that creates a tension. So because scammers are using it, so masking more data isn't really going to solve the scamming problem. I think the open data portal that we're talking about will get us closer to a way to the trademark portal that we were talking about, your bar, your banking app model. I think that gets us closer to a place where data masking is not really on the table anymore because scammers really aren't. You would be able to ignore all scammers. It would never work because you would only get communications through the portal, and that would be it. So that was a bit rambling, but it's a sensitive topic. I know privacy is a sensitive topic. We take it very seriously here, but the data that we've collected isn't private, and it never has been. So when we try to mask it as a courtesy, it ends up sort of blowing up in our face because the scammers can get it from bar websites. They go and scrape the California bar website for attorney credentials. They don't need to come to our filings for those. So that was a bit rambling. I apologize, but it is a sensitive topic. But I don't think data masking is going to solve the problem. I think there's a better approach, and we think we're headed towards that. What can outside counsels do to assist the USPTO with its current efforts to combat fraud? Oh, gosh. We would encourage use of our third-party tools, reexamination, expungement, non-use proceedings, cancellation proceedings at the board, letters of protest. Like I said, use those to attack the fraud that you see and that you have an interest in addressing. You certainly can send us information at tmscams@uspto.gov. But as I said, we get, 100 emails a day, maybe more, it depends. And we have a few people manning this box, so we cannot take action immediately on everything that we get. That tool that we were talking about, that the customer resource management tool that will allow us to manage those tips, that will really help. But it's certainly it's a huge, it's like a fire hose of information coming to us, and we can only handle so much. But certainly if you see that there is a US licensed counsel who appears to be in cahoots with a foreign filing firm and doing bad things, you should file a grievance at the Office of Enrollment and Discipline. And that is grievance at USPTO.gov. Is that right? OED at USPTO.gov. OED at USPTO. You can file and send an email to the Office of Enrollment and Discipline if you see that there's attorney misconduct going on, and then they will start an investigation and look into it. They go through their process, and if something comes out, something is published that identifies that a particular attorney was responsible for a particular set of filings, and they're riddled with rule violations, then Montia's shop will take that and issue a sanctions order on those, against that attorney, against that filing firm, whoever they were working with, and try to get rid of those scam applications off of the register. So we're all in working together here within the USPTO to try to act on the tips that you send us. Can you think of anything else, Montia, that outside attorneys can do to help?
Maybe report misleading ads with Google. We've been doing that ourselves, right? When we see false associations with us and other, clearly scam, offers on the site. I think a lot of the website providers have their own link to report to get those ads taken down. So I know Google has one. I assume Bing and other places have that as well. And that would help us a lot because we try to do that regularly. But again, it's just we have limited resources. So if everyone sort of reports the bad stuff that they see regarding the false and fraudulent ads, I think that would help us as well.
And also to the Federal Trade Commission. So the Federal Trade Commission has a fraud reporting link, and if you report trademark fraud to them, they aggregate the trademark fraud, and then they see that there is a problem, and maybe they can use their government impersonation rule to go after it. But I see that I talk so much, and it's 1:02, so we need to wrap this up today. I really, really thank you for joining Montia and myself today. This has been fun. We will try to answer the questions that we can out of the email box, so don't worry if we didn't get to your question today. But we hope you enjoyed this, and if you do have further questions on it, you can continue to email that box and we'll take a look at it. So thank you for joining. The recording will be available in a couple weeks on the USPTO Hour website. So thank you for being with us today.